Appeals for judgment. Director General Mauritius Revenue Authority versus Central Water Authority.
This appeal relates to the period September 1998 to May 2000, which was immediately after VAT was introduced in Mauritius. The issue is whether the Central Water Authority was in that period entitled to claim in its VAT returns as input VAT, VAT which it incurred in acquiring water meters to fit in customers' properties and in undertaking infrastructure works to construct or maintain the connections between such meters and its water mains in the street. Customers wanting a water supply pay an initial connection fee, a symbolic rent of 10 rupees a month for a meter, and no specific sum for subsequent maintenance. They pay statutorily fixed charges for water actually supplied. The VAT Act 1998 came into force on 7 September 1998. Under it, the supply of water to customers was standard rated, save for the first 15 cubic meters per month supplied to any customer, which was exempt. By regulations made on the 22nd of September, and it appears promulgated on the 3rd of October 1998, an additional exempt category was added with effect from 7 September 1998, in other words, retrospectively, consisting of the renting out of meters and the carrying out of infrastructure works. So, argues the Mauritius Revenue Authority, if the supply of meters and infrastructure is exempt for VAT purposes, then the costs of acquiring such meters and undertaking such infrastructure works cannot be allowable. There is nothing to allow them against. Not so, says the Central Water Authority. The meter and infrastructure costs which it incurs are part of the costs of making an indivisible supply of water to customers. They should be allowable against the VAT charge for water supplies. And the VAT Act and the regulations didn't authorize the Minister to make regulations with or achieve any other effect. As a secondary point, the Central Water Authority argues that the amending regulations could not in any event legitimately deprive it retrospectively of the right to input tax on meters acquired or infrastructure works undertaken in the very short period between 7th September and 3rd October 1998. The Water Authority won before the Assessment Review Court and the Supreme Court. The matter has been argued by the Revenue Authority before the Board with a differing emphasis to the way in which it was presented below. Below, the Revenue Authority contended that although the renting out of meters and carrying out of infrastructure works would normally be regarded as part of the supply of water, the effect of the amending regulations was to require these elements to be seen as completely separate supplies. Before the Board, the Revenue Authority, while not formally abandoning its original case, has argued primarily that assuming there was only one overall supply of water to customers, it was nonetheless open to the legislator to identify a concrete and separate aspect of the overall supply as having separate treatment for VAT purposes. In support of this analysis, the Revenue Authority has referred the Board to case law of the European Court of Justice. The VAT Act 1998 is framed on a significantly condensed basis on the general model of the United Kingdom's VAT legislation, which in turn gives effect to the European Union's VAT directives. The Water Authority hasn't taken issue with the general principles set out in the EU case law, but it argues that the VAT Act 1998 contained nothing to enable the making of regulations altering or affecting the concept of a supply, that the renting out of meters and the infrastructure works are merely the means of supply of water, especially when they were supplied largely free of charge, and that there was no basis for distinguishing them from the infrastructure works undertaken to construct, say, water mains, which were on any view an integral part of the Water Authority's business of supplying water. The Board rejects the Water Authority's submissions and accepts the Revenue Authority's case. Although they are indeed a necessary prerequisite to the supply of water to any customer, the renting out of meters and the connection and maintenance of the connection between the customer's premises and the mains are important, concrete and specific elements supplied to the customer as part of the overall supply. It was open to the legislator to deal with them differently for VAT purposes, and this the Mauritian legislator did here by the amending regulations during the relevant period, after which there were further amendments and the present issues no longer arise. As to general infrastructure works undertaken to construct and maintain mains, These could not be related to any supply or any concrete or specific aspect of any supply to any particular customer. They were general overheads outside the scope of the exempt provision introduced by the amending regulations. As to the Water Authority's specific argument that the amending regulations could not legitimately affect retrospectively the short period between 7th September and 3rd October 1998, this doesn't appear to have been part of the Water Authority's case below. There are no findings of fact about its implications, which the Water Authority anyway accepted would only be of marginal significance. The Board doesn't therefore consider that it should address the argument further. The Revenue Authority's appeal is therefore allowed. The Water Authority is not entitled to credit for the input of VAT which it incurred acquiring meters and undertaking infrastructure works to construct or maintain the connection between those meters and its water mains in the relevant period.